Dr. Kizza Besigye was in Kenya, Nairobi specifically, for a book launch. Instead, he was abducted by operatives believed to be from Uganda and collaborating with those from Kenya, driven across the night, and then produced at the military tribunal in Machindi. This Friday, 11th of April, he will reappear at the High Court International Crimes Division for a ruling on his bail application filed 2 weeks ago. So what is bail and what are the chances that Dr. Kizza Besigye will be released on Friday? The basis of bail is the presumption of innocence under Article 28(3)(a) of the 1995 Constitution. Under that article, persons accused of offenses, criminal offenses, such as theft, robbery, or in the case of Dr. Kizza Besigye, treason, are presumed not to have committed that offense unless such a person is convicted or they plead guilty following a given set of procedures. So, in regard to that, such a person is allowed to apply for bail, which is also provided under Article 23(6), the right to apply for bail. If the judicial officer thinks whoever is before them and has applied for bail deserves bail and will continue to attend court from home without being in jail, they can grant such a person bail. However, there are 15 considerations under the Constitution into bracket bail guidelines for courts of judicature, close bracket, open another bracket, practice, close bracket, directions 2022, and case law that Ugandan courts have routinely based upon to decide whether one gets bail or not. The first, the gravity of the offense. How serious is the offense? That could be, by way of the example, a case where someone steals 1 chair and another one steals 100 chairs. It is taken that the one who has stolen 100 chairs has committed an offense that is of higher gravity as opposed to the one who has just stolen a single chair. 2, the nature of the offense. If one has stolen a chair and another person is accused of committing murder, the person accused of stealing a chair is more likely to get bail as opposed to the one that has been accused of murder. 3, the antecedents of the applicant so far as they are known. This basically talks about the history of whoever is applying for bail. Some people have a favorable history, especially in courts, given their conduct, given their record, as opposed to others. 4, the possibility of substantial delay of the trial. Ugandan courts are faced with something called case backlog. That means that cases are not always determined in the shortest time possible. As a matter of fact, there are people in prison whose cases have gone on for over a decade. So in that case, it is just the logical thing that the courts would give someone bail so that they face trial from home instead of being in jail, and to the sad reality of many people, at the end of it all turning out to be proven not guilty of having committed the offense in the first place. Number 5 is important, especially in Besigye's case. The age of the applicant, their physical and mental condition. Besigye is 68 years old. Normally, older people get bail easier as opposed to younger people, because then older people are more likely to fall sick and have other conditions that should keep them home as opposed to being in jail. The physical and mental condition is also important, and you know that Dr. Kizza Besigye has been sick for a long period of time as far as he has been in jail, and that may work in his favor. The likelihood of the applicant to attend trial. Applicants who are unlikely to attend trial once they are given bail are more likely not to be given bail as opposed to those that attend trial. Remember, we said that the basis of bail is to ensure that one attends trial from home. Dr. Kizza Besigye has been arrested several times. Many times he has been released on bail. But as far as the records show, he has never absconded bail, and so that works in his favor. The stage of the proceedings. If a case has proceeded for a long period of time and is towards the ruling, one is less likely to get bail. If the stage is in the middle, one is probably having high chances of getting bail. And if the case is at the start, also there's a higher likelihood that one can get bail because the trial could then take much longer. The likelihood that the likelihood that the applicant, the person applying for bail in that case, will commit an offense while on bail. So if a person is likely, if the court assumes the person is likely to commit an offense while given bail, the court will will not give them bail on the basis of that. Next is the likelihood of the applicant interfering with witnesses. Once trial is underway, the court ensures that witnesses are not tampered with, witnesses are not threatened, witnesses are not witnesses are not put in a situation where the applicant, the person applying for bail, the accused in this case, interferes with them and so renders the case, puts the case in such a position that it becomes harder for them to speak their minds as they freely would. The safety of the applicant, the community, and the complainants. There are cases where people accused of various offenses are released on bail and then maybe a mob hits them and kills them. If the court thinks that that is likely, the court won't give the person bail for their own safety. In the same way, if such a person is going to put a community or a society at risk, the court will not give them bail. And the same is true if they are going to, let's say a person is accused of theft, if they are going to in a way put at risk those that have accused them of the theft, the court is less likely to give them bail. Next is whether the applicant has a fixed place of abode in Uganda. A place of abode is basically a place of residence. If a person has a home in Uganda that is permanent, in this case Besigye does have one and it's in Kasagati, I assume most of you know that, that person is more likely to get bail. 12. Whether the applicant has sufficient sureties within Uganda to undertake that the applicant shall apply with the conditions of bail. So sureties are people who will stand on behalf of the applicant and say, we know this person, we can ensure that they attend trial. Sometimes the sureties are even made to commit to pay a certain sum of money if that person doesn't attend trial. So the substantiality of the surety is basically whether the person has some level of control, some reputation that they risk losing if they don't compel whoever is granted bail to attend trial. So that becomes an important thing. And in this case, Besigye's sureties, I think, are very, very competent people for that role. 13, whether the applicant has a history of failing to comply with bail conditions in the past. Like I said, Besigye has been given bail several times. And on each of those occasions, the record is that he has attended trial whenever he was called upon. So this will most likely work in his favor. 14, and that is the second last, whether there are other charges pending against the applicant. So if the other charges pending against the applicant, the court may be more reluctant to give them bail in a particular case. So as far as we know, there are no such other charges pending against Dr. Kizza Besigye. Whether the offense for which the applicant is charged involved violence. So offenses such as armed robbery, murder, rape, that involve a level of violence, a level of harm to people, put someone in a position where they're less likely to get bail for fear that when they get bail, it is kind of a sort of injustice against the person whom they harmed. So those are the 15 conditions that we know the court will base on the 11th, which is this Friday, to determine whether Dr. Kizza Besigye, 4-time presidential aspirant, will get bail or not. How the axe will swing, we don't know. How the pendulum will go, we don't know. But we wait to see. And of course, we hope for the best that he gets bail on Friday. Thank you.